Thank you very much, Mr. Thanuwatt. And now, ladies and gentlemen, we have commenced into the last sessions of the World Judicial Integrity Forums of 2026. So, my name, once again, is Nhonlaphat Pitpiboonpreeya. I am the director of the Bachelor's of Laws program, Rangsit University. And I will be the moderator for your last sessions here. In these sessions, ladies and gentlemen, we are going to comments in regarding the strengthening of judicial cooperation, cross-border cooperation, and institutional exchange. And we are honored to have the expert, both from Malaysia and from Thailand as well. So ladies and gentlemen, please welcome our first panelist, Mr. Philip Teoh from Malaysia. He's partner, international lawyer, and arbitrator of Azmi and Associates. Our next panelist is Police Captain Amornphan Nititheeranont from Thailand. He is former judge and currently the Senior Advisor, Acting Assistant Secretary General of Personal Data Protection Committee. And our next panelist, even though she's not here today, but she sent us the pre-recording of her remarks. She is Ms. Yujie from China. She is researcher of China-ASEAN Legal Research Center, Executive Deputy Director of the Overseas Interest Protection Center of the Southwest University of Political Science and Law, the residence expert of Chongqing International Center for Policy and Legal Service of Airport Economic Zone, and also the foreign legal expert advisor of Southwest University of Political Science and Law, China-ASEAN Legal Research Center. And our final panelist for these sessions, ladies and gentlemen, is Police Lieutenant Colonel Worakorn Nattamangkang from Thailand. He serves as Inquiry Inspector and Investigator in the Subdivision of the Investigation Division of Thai Immigration Bureau. Ladies and gentlemen, as Asian countries become more connected, it is inevitable that we have to strengthen our judicial cooperation, especially in terms of the cross-border legal coordination and institutional exchange. So in these sessions, we are going to tackle the practical mechanism of judicial collaboration among Asian jurisdictions, including procedural collaboration, information sharing, and judicial training. And we're also going to discuss how to promote the international collaboration, deepen legal understanding among Asian courts, while respecting the national sovereignty and distinct legal system and legal tradition of each nation. And we hope to gain this practical approach from our panelists today. So without further ado, ladies and gentlemen, I would like to invite Mr. Philip Teoh to commence his opening remarks.
Good afternoon. I am pleased that I've been invited to speak at this conference. What I have heard so far this morning is contribution from experts from different countries. And you can have integration of the legal aspect and the judiciary system in ASEAN. Before you have integration, you must first have understanding. And the understanding, we must try to understand how each country's laws operate, how each countries decide cases through their own judiciary or through other methods of dispute resolution. So this includes very prominently arbitration. And each country have their own arbitration center. In fact, several years ago, I argued a reinsurance dispute in the Thai arbitration center concerning Thai reassured insurance company against a Malaysian reinsurer. And in Malaysia, we have our own center, the AIAC. And in some countries, there's more than one center. In fact, the countries of China, they have multiple centers. Countries of India, they have multiple centers. Actually, in this area, more is not necessarily better. It confuses the user. It confuses the business. So to a large extent, a lot of Indian businesses refer their cases to the Singapore Arbitration Center. I want to give some overview, which my slides will present. So the Malaysian legal system, like Singapore, like Hong Kong, we have what is called a colonial past. And because of a colonial past, a lot of the laws of Malaysia have British origins. Example, I do a fair bit of shipping. The Merchant Shipping Ordinance derives its origin from the Merchant Shipping Act, UK, 1894. Malaysia also have a Contracts Act. Our Contracts Act derived from the Indian Contracts Act, 1894, which is a codification of the English common law. And in fact, in many areas, we still have a continuing reception of English law. For example, there are provisions in the Civil Law Act, and when you insure cargo or ships under marine insurance, the forms of insurance, they use English forms. And in the English forms, you have what is called a choice of law, choice of English law. This raises the issues of conflicts, which I will cover in a short while. Malaysian courts are courts in the common law tradition. Our courts are run on the adversarial basis. As contrast to courts in Indonesia, courts in Thailand, because the Indonesian and Thai courts are of the inquisitorial system. And in Thailand and Indonesia, you have what is called a civil code. In 2012, I argued in Singapore a breakdown of a joint venture dispute where the agreement was subject to Indonesian law. And under Indonesian law, the whole dispute had to be tried under the civil code. And actually, Malaysian courts and arbitrators too, we can apply foreign law. So in the arbitration case, what happened was, I'm the counsel, and the three arbitrators were mainly common law lawyers. However, the arbitrators were still able to decide under the applicable governing law. And how did they do that? Parties had to bring in the expert foreign law experts, and they brought in, each of them, lecturers from universities of certain repute. Similarly, in the Malaysian courts, if there is a dispute and the contract of the parties in dispute say apply Chinese law. So what? Of course, the judges, the Malaysian lawyers, will not understand Chinese law. Again, they will bring in experts for that particular law. However, if the matter concerns English law, to a great extent, we can refer to textbooks. And understanding the different laws, applying the different laws when there's an issue. Obviously, if you have a breakdown of a joint venture between a Thai party and a Malaysian party, the first thing you need to do is look at the contract. Is the contract subject to any particular law? And you will decide how to go about resolving the dispute under that particular law. This is the issue of conflicts of law. conflicts of law is very important in this area. In the two main areas which I handle, international arbitration and shipping, it always rises. For example, the cargo which is carrying the Malaysian exporter's ship is a Japanese carrier, okay? The Japanese carrier, under the contract, the bill of lading provides for any dispute, it should be filed in the Tokyo District Court. And the other aspect about dispute between companies of different nationalities, one must realize, after the dispute is tried, how are you going to enforce the dispute? Actually, the courts are not so, how to put it, efficient universally. Malaysian court judgments are recognized in very few countries, and the countries are Singapore, Hong Kong, several states in India. However, if you have an arbitration award between an Indonesian party and a Malaysian party, that award can be enforced in 172 countries under the New York Convention. And to a great extent, the courts in Singapore and Malaysia are arbitration friendly. So again, this is a conflict issue. If in the contract there's an arbitration clause, you bring the case in the Malaysian court, the judges, upon application by one party, will say, look, this is not a proper forum. You go to arbitration. However, certain actions can be taken in the Malaysian court. For example, ship arrest. And in fact, that also brings me to one particular topic. The newly set up division of the Malaysian court, International Commission, ICAT. Basically, what this court, which is a court in the KL High Court system, it decides on disputes between foreign parties, and it also subsumes the jurisdiction of the former Admiralty Court. This is ICAT. I do appear quite often. In fact, 3 weeks ago, we arrested 2 vessels, and up to today, while I'm here, my lawyers are having cases before the judge. So ICAT was set up in 2nd of March this year, and according to the Chief Justice of Malaysia, the purpose of ICAT is to try cases involving foreign parties and as well the Admiralty Court. The Admiralty Court was set up in the year 2010. The very first Admiralty judge was Tan Sri Nalini, who later became the federal court judge. She retired sometime in February. And I have been trying cases before her court. In fact, I argued the very first reported case of her court. So what is the whole purpose of the Admiralty Court? The whole purpose of the Admiralty Court is to have a court where there is expertise by the decision maker, and in fact, by virtue of the establishment of the court, it also helps to promote the maritime lawyers' expertise. What is the difference between Malaysia as a common law jurisdiction, the adversarial system, and the civil law inquisitorial system? In fact, the prominent aspect is the court and the judge is independent, impartial. In some civil law courts, the judges have what is called an inquisitorial role, meaning they will investigate issues which may not have been fully raised by the parties, But the Malaysian courts do not do that. It is left to the counsel of both parties to raise issues for and against their case. And I heard this morning about advancement technology. The Malaysian courts are very used to online hearings. So if you have trials, what the courts have done, if they have reverted back to physical hearings. However, if you have interlocutory applications, these still are commonly handled through online hearings, through applications like Zoom. And this advancement after COVID saves a lot of time. In fact, previously, if we have what is called a case at the case management stage, we had to go to the court and wait from 9 a.m. to 12 o'clock because the judge will be hearing other cases. So we have to be in court. However, now, where we can have the hearing by Zoom, we can be in our office. We can, in a way, not save time on travel, and also be able to do other matters before our hearing start. And this is a security for cause application hearing, which I handle with my lawyers. Before the case goes for trial, the Malaysian courts would have what is called a court annex mediation. In a court annex mediation, the parties are given a chance to refer the case to a different judge, a judge who's not going to try the case. And what the judge will try to do is try to explore both parties' case. However, the role of the mediating judge is not to try the merits before the trial. He is trying to convince the parties to come to a compromise. For compromise, and if the mediation succeeds, parties will enter into a consent judgment. If it fails, then what happens is it reverts back for trial. And because we have an adversarial system, you need to bring witnesses. Witnesses, whether the particular persons are cogent, they have personal knowledge of the matter. This is important. If the witnesses are brought of crucial facts, then you have a loophole in your case. And we also use what is called witness statements. Witness statements are very important. In fact, these are prepared by lawyers, but as lawyers, we need to go through with the witness. I had several cases where I cross-examined parties. You look at question number 3, referring to this document before the trial. Have you seen this document? And that witness says, no. Then there was another case, a case where dangerous goods cargo exploded, sinking my client's ship. The chemist gave 4 pages of the packing. I asked, were you present during packing? He said, no.
We have to conclude.
Yeah. And this is arbitration. What's the main difference in arbitration is that the person who decides is a chosen dispute resolver, and this is chosen by the parties. Yes, I think I've come to the end of my presentation.
Okay. Thank you very much, Mr. Philip Teoh. And now I would like to ask Mr. Amornphan to deliver your remarks.
Okay, good afternoon. I will share between the gap in a borderless world now. The first, we want to know what the key challenge faced by the ASEAN judiciary in strengthening cross-border legal cooperation. I see in Malaysia have online court, but do you know in Thailand, in Thai law, the online court hearing is allowed for domestic only, not for international hearing. When dispute enter our court today, they are rarely confined without our border. We face distinct challenge in both criminal and civil sphere. I think Police Colonel Lieutenant Worakorn will share in criminal sphere, but now I want to share in civil proceeding. The primary obstacle is the service of judicial document. You can see example in this slide. Courts often rely heavily on diplomatic channel, and this process is slow now. Even more challenge is the execution of judgment and seizure of assets because the court authority general end at the nation border. In Thai law, to resolve this issue, we must embrace 3 pillars of reform: harnessing technology, aligning domestic law with global standards, and building 24/7 network and data integrity. Okay, the next topic is I want to share the handling cross-border commercial dispute. How can judicial coordination will be improved to reduce uncertainty and delay? That I say that the most problem is the delay for document legal. One of main challenge in cross-border commercial dispute is delay. I know many people may have heard the saying, justice delay is justice denied, right? Especially when courts need to send legal document about or enforce judgment in another country. To improve this, ASEAN countries should strengthen judicial cooperation, use more digital technology system and electronic communication, and continue improving legal coordination between jurisdictions. I know now Thailand have cooperation with another country, only 6 countries in judicial legal. And the low technology and digital platform play in facilitate cross-border judicial cooperation. We must use technology to bridge the time gap in international law. Technology can improve communication, evidence sharing, and coordinate between jurisdictions. Within our courts, we are expanding the electronic service of process and verify digital system. We can reduce notification period from month to month day. As my office of we call the PDPC Thailand, we regulate personal data protection. We also see that international cooperation must move toward real-time information exchange. Under our framework on technological crime, financial institution and telecommunication provider, are able to exchange information more rapidly to assess suspicious transactions and cyber related offenses. Globally stronger digital cooperation and secure information sharing system will become increasing important of effective cross-border judicial cooperation.
So now I would like to invite Police Lieutenant Colonel Worakorn Nattamangkang to deliver your opening remarks.
Okay. I'm not the academia. I'm the practical officer that I will say that something in reality, the problem, the conflict about the border enforcement and humanitarian protection. I attend two international conference in 2019 Trans-Confessional Conference, and then the last year, the ASEAN Pole Conference. I want to tell you that everything has changed so far for the situation about the crime in ASEAN and its impact internationally. So we will talk about the problem in current situation. Now we know that the ASEAN is a very popular region from the world now. We have the several countries, several legal systems, several courts, several believe it. It's very diverse. If compared to the other region of the world, you see that the Thailand link up to the land border to the Myanmar, Laos, Malaysia, and Cambodia. In the maritime of the ASEAN, we have the naval border connect to the Indonesia connect to Malaysia, and Brunei had a land connect to Malaysia. So why is the problem is complicated? What I saying about is the national security and human rights obligation. In the three pathways of the judicial system of the ASEAN, we have three pathways. First is a domestic legal system, and international relation, and the law enforcement between the country. What is the problem? Because the national security in each country in ASEAN have own agenda. Moreover, we have the United Nations treaty or agreement that to accept. Right in Thailand, for example, we signed the refugee treaty to accept the refugee. But in reality, we did not write any law to support them. I think it's a worldwide problem. So when the UNHCR accept the refugee, they are also overstay in Thailand, and police can catch them and go to the court, to the judicial system, and judicial sentence them, get the penalty, and the judge lead them to the public. It's a loop, right? This endless loop. What's the problem of the judicial court in ASEAN? Not only Thailand. Why it happened? There's someone that evac from some country to enroll to be the refugee, but the local system, local legal system doesn't support them. What's it happen now? It's a question that everybody should answer. Now, today, you will see that the asylum seeker, the refugee, and the normal criminal, that we should identify first what is happened, what they do, what they did, what is the real problem behind them. Some country require the criminal in Thailand, but they have double status. They are the criminal of some country and the refugee of the UNHCR. This is the recent problem of the international relation today. And now, furthermore, the problem is more complicated because it have the scammer and human trafficking, modern enslavement. The problem that we had to identify them. What is the victim? What is a criminal? It's a very sensitive issue now for law enforcement and legal system that challenging us today. You see that? The autonomy of human trafficking, recruitment. Somebody, maybe outside ASEAN, around the world. I met them every day. Bangladesh, India, Brazilian, somebody from African, Nigerian, went to some country in ASEAN and did the bad thing, like the scammer, to scam and get the money from somebody in Japan, Spain, England, UK, United States. The question is, they did in some country. They scam, they had the base on some country. They had the compound for some country. And they scam also people in some country, very far away, but connected by internet. Which area of legal system that it shut them? This is a problem. Then I encounter today many cases. This is a question that without the answer today. How do court respond to them? Now, the problem is more complicated. When we, in terms of issue of the human trafficking law, if they are victim, but they also did the crime, committed a crime, how we identify them? If they are the victim, we have the process for the protection to the court, to the judicial. So, who are them? Criminals or victims in legal system? How do you know that they are innocent? They just go because they earn wealthy, earn good income, or they intend to attend the criminal organization. This is a question that judicial system should answer. How to identify, how we protect the innocent, how we sentence the criminal. It's not the problem is not already ASEAN. You see that in the red line, confirm is the victim trafficking, but somewhat but in general line, it's very important because we know it's a criminal or victim, but we have no evidence. Because the evidence is far, far away in another country. How the judge can believe them? They torturing, they scamming. How is the weight of the evidence that judge should identify them? And I want not to talk about the Burai because it's very clear that it's not a victim or anything. But the problem is not the court, the different method about the judicial system, but we also have the United Nations commitment. There's a problem. The question is, we have the global standard and the domestic operation. And I forget to put it in the slide is the regional operation. Like I attend the conference. It's really a complicated problem. Sometimes the criminal that some country claim they are the criminal, but in some country it's not the crime. That's a problem because but sometimes it's a political opinion. The armed groups or insurgent, religion persecution, race, ethnic violence. But the UN accept that. But in the local law system, they are the criminal. They did the crime. How about the question? How about this problem? What would be next in Thailand? I think it's the same. It's around the world. When we have sometime, we have somebody that committed a crime, and we remove and depart them back. But some term is not about the overstay or committed a crime from the local, but it's the government is the far away not require us to catch them and bring them to the system. In the history of Thailand, we have one case that very popular, that when we want to depart, which country that depart is the case of the Mr. Victor Bush. He's the armed group, not armed group, it's the armed merchant. He the citizen of the Russia, but the United States want them to bring them to the United States, to the judicial system. And this case had brought to the Thai legal system, and court justified that between Thailand and United States have obvious protocol, obvious treaty we signed about the criminal. So then the court depart them to the United States. In also way, Russia also veto us that the United States use the political pressure under the Thai court. So the question is, which country that have the legitimacy to bring them? You see that? The border control is very, very complicated and very important. It's about security and service. Two pathways, two issue, very big issue. But it's very contrast. How we maintain the security and also provide the service. You see that? The slide with a pipeline about diverting. Now, I think it's for the conclusion. The problem is not only the problem of the difference between the legal system from each country, but we also have the United Nations agenda to accept that because we are all the members of the United Nations. And finally, I think the question that we should discuss in this forum, that how we accept the middle way together. What is the middle way? What is the consensus of the legal system that we can accept together?
Today, on the topic of strengthening judicial cooperation through cross-border legal coordination and institutional exchange, with a particular focus on the China-ASEAN region. I will also extend this discussion to an emerging yet underexplored issue: the regulation of private security actors in cross-border contexts. In recent years, the intensification of economic integration and transnational mobility between China and ASEAN has not only facilitated regional development, but has also generated increasingly complex legal challenges. Transnational crimes, including telecom fraud, human trafficking, and cyber-enabled offenses, have expanded both in scale and sophistication, raising significant concerns for regional governance. This development suggests that purely domestic legal responses are no longer sufficient. Current regional trends further illustrate this growing tension between deepening integration and expanding cross-border risks. China-ASEAN trade has continued to grow rapidly in recent years, exceeding $1.2 trillion in 2024. At the same time, cyber-enabled fraud and transnational crime activities across Southeast Asia have also increased significantly. This development demonstrates that closer regional connectivity not only creates economic opportunities, but also generates more complex legal and regulatory challenges that require coordinated judicial responses. Against this backdrop, judicial cooperation has evolved from a technical legal mechanism into a central component of regional governance. This transformation can be understood through the lens of non-traditional security. Rather than focusing solely on state-centered threats, cooperation increasingly addresses transnational risks that cut across jurisdictions and involve both state and non-state actors. Existing frameworks between China and ASEAN already reflects this shift. For example, the China-ASEAN Plan of Action 2026 to 2030 places explicit emphasis on mutual legal assistance, prosecutorial collaboration, and judicial capacity building, alongside the institutionalization of regular exchanges among legal professionals. Such initiatives indicate a gradual movement from fragmented national responses toward more coordinated regional approaches. Moreover, cooperation has expanded beyond traditional crimes to include cybercrime and financial crime, reflecting an ongoing shift toward more integrated and institutionalized forms of governance. Recent developments in regional security cooperation further demonstrates this trend. Along the Lancang-Mekong River, China, Laos, Myanmar, Thailand, and Vietnam have institutionalized joint law enforcement patrols and established integrated security cooperation mechanism to combat cross-border crimes such as drug trafficking and telecom fraud. At the same time, ASEAN and China continue negotiations on the South China Sea Code of Conduct, which aims to provide a more stable and rules-based framework for managing maritime disputes and reducing regional tensions. These initiatives reflect a broader shift from fragmented responses towards more coordinated and institutionalized regional governance. However, despite these developments, significant challenges remain. One of the most persistent issues lies in the diversity of legal systems across ASEAN member states. Combined with China's distinct legal framework, differences in evidential standards, procedural norms, and extradition practices continue to complicate effective coordination. As a result, cooperation often depends on ad hoc arrangements rather than fully harmonized legal mechanisms. It is within this evolving landscape that the role of private security actors become particularly salient. As Chinese overseas investments continue to expand across Southeast Asia, private security companies are increasingly involved in protecting assets and personnel. Recent regulatory developments illustrate both the opportunities and risks of this trend. For instance, Myanmar's Private Security Services Law, enacted in 2025, establishes a legal framework for the operation of both domestic and foreign securities providers, while requiring coordination with state authorities. This raises important questions. Private security companies operate outside traditional state law enforcement systems, yet they play a growing role in cross-border security governance. Without proper regulation, this may lead to unclear accountability, blurred enforcement authority, and potential human rights concerns. In light of these challenges, it is increasingly important to broaden the scope of judicial cooperation beyond traditional state-to-state mechanisms. This may involve developing shared regulatory principles, enhancing information exchange, and establishing clear frameworks for supervising non-state actors operating across borders. At the same time, strengthening judicial cooperation also requires sustained investment in legal capacity building. This includes expanding judicial training programs, promoting cross-border professional exchanges, and supporting the development of international competent legal professionals. Such efforts are essential for improving mutual understanding and ensuring effective implementation of cooperative frameworks across different legal systems. In conclusion, judicial cooperation between China and ASEAN is undergoing a significant transformation from a set of technical legal interactions into a more comprehensive system of regional governance. Addressing emerging challenges, particularly those associated with private security, will require deeper legal coordination, stronger institutional trust, and a more inclusive approach to regulation that reflects the evolving nature of cross-border security. Thank you.
Thank you very much. So now we are having some time left, a little bit, for the panel discussion, approximately 5 minutes. So we are going to ask and answer in brief, okay? So for Mr. Philip Teoh first, is it possible that we could have a recognition and enforcement of foreign judgment across Asian jurisdiction, or we do have to strictly respect the sovereignty of each jurisdiction?
It's not so much respecting sovereignty. It's having the statutory framework. So if you want to look at, example, Thailand, the Thai court judgments, Thailand has to enter into a reciprocal law or arrangement with other countries. Because, example, Thai judgments are not recognized in Malaysia. It's only if the Malaysian Recognition and Enforcement of Judgments Act includes Thailand. But it will not include Thailand if Thailand doesn't have a similar law. So that is why arbitration is the logical way to have judgments recognized and not so much it's called awards actually, recognized and enforced.
Okay, thank you very much. And now moving fast to Mr. Amornphan, that I would like to ask that nowadays, what are the most significant challenges and obstacles in Thai judicial process when the international dispute reach the court? And how should we strengthen cooperation with the international community to effectively overcome such issues?
Okay, I just say that and show in my slide there's very challenges when the dispute enter our courts today is about very conflict within our border. We face distinct challenge in both criminal and civil spheres, such as when we send legal document. Sometimes we use 6 to 12 months for one document. We need to translate and set it in diplomatic channel. And in criminal sphere, Mr. Worakorn shared as human trafficking. I will share another about extradition. In Thailand, we have the extradition law, but in real practical, we use deportation in Immigration Act. Don't use the extradition law because it uses many more time, and sometimes exception about the political criminal and social criminal. I think that many countries use the diplomatic channel, not in court channel. Back to the civil sphere, I will think to resolve this problem, we need to have the cooperation in ASEAN country. We need to have 24/7 and networking. The last year, Thailand signed the UN Convention in Criminal Asian crime as the Vietnam. We need to use the technology, digital system to share the digital evidence to the court. And I think this is not digital system only. We need the security. It's very important for the legal document to comply with cyber security law and cyber security standard. It will help the gap time to from the many time will shortly.
Okay, so Mr. Worakorn, in brief, we have only 1 minute left. So you have mentioned many key challenges, okay? So what is the most critical way to solve such challenges that come in your mind, like the most crucial one?
The most crucial one is we must accept that the politic is the most important from the judicial system, international judicial system, because it's some term very sensitive. For example, I went to the European Union. The commitment is different from the ASEAN. It's a hard commitment. They have court, they have parliamentary rigorous system about the EU, but ASEAN don't have. ASEAN, when have the conflict between the raw or immigrants, that they use the diplomacy. They use the soft way to solve the problem. The critical thinking, the critical problem is about how is the relation between, how the commitment between the nation. If we can answer this question, we will answer the problem of the all thing. Thank you.
Thank you very much, all the panelists. And now I hand the stage back to Mr. Thanuwath for the appreciation section. Thank you.
Thank you very much, Ms. Lily, for a very, very fruitful discussion together with all the panelists here. And again, before we proceed to another, excuse me, please remain on the stage. So right now, I would like to invite Dato' Siti Harjini Suhaimi bin Nik Suholaiman, Organizing Chairman and Legal Advisor to the International Strategy Institute, to present the token of appreciations to our panelists. Take a good photo together.